this case, returned by a state indictment, faces 34 felony counts of falsifying business records, and it's called the first degree, all of which are tied to the former president's role in a so-called hush money payment. We'll talk about that again in just a moment or so, to a woman named Stormy Daniels. At least that is her commercial name, if you will. That payoff is not the only hush money deal that prosecutors who are planning to highlight in this case. The prosecutors from the Manhattan District Attorney's Office, the DA there, his name is Alvin Bragg, have accused Donald Trump through the grand jury indictment there of orchestrating a broader scheme. And we've talked a lot about this on this broadcast, to influence the 2016 presidential election by purchasing damaging stories about them and keeping them effectively under wraps. That's the focus. That's the theory of this prosecution generally. Again, the first of 4 different criminal cases presently on the docket, if you will, of the former President Donald Trump in trial courts around our nation. Now, let's talk about some of the basics of this, which we have again discussed before, but important to lay some groundwork once again on our weekend show. The charges, as I indicated, take back to a $130,000 hush money payment that Trump's so-called fixer and lawyer, you know him, his name is Michael Cohen, apparently made to Stormy Daniels in the final days of the 2016 campaign. That payment, which Cohen said he made at Donald Trump's direction, suppressed her story of a sexual relationship liaison that she says she had with Donald Trump. That's the core basis of this lawsuit. That's the core basis of this prosecution. Now, significantly, it's important to note that paying hush money is not always illegal. There are situations where contractually one can enter into agreements for the non-disclosure of information. It may also include money payments. But while serving as the commander-in-chief, the president of the United States of America, according to the allegations in these charges, Trump reimbursed Cohen, and how he did so constituted fraud. And that manner of the repayment, that reimbursement, is the focus. That's the legal focus of this trial beginning on Monday. In internal records, Trump's company classified the repayment to Cohen as legal expenses, saying these are things that Michael Cohen did on behalf of the organization or behalf of Donald Trump. And they cited a particular retainer agreement that in fact existed between Michael Cohen and Donald Trump, yet there were no such expenses. That's the allegation, the case. And the retainer agreement was fictional in terms of its application here as well. The records underpin the 34 counts, the 34 state counts of falsifying business records, that in violation of New York state law. That is why this is a state case. That's why this is a criminal case brought by Alvin Bragg, brought by the DA's office there in Manhattan. 11 of those counts involve checks that were written and dispersed to Michael Cohen, ultimately payments made to Stormy Daniels. 11 more of them center on monthly invoices Cohen submitted to the company, again, fraudulent documents to try to reestablish and confirm something that in fact was not the case. And 12 more of those counts involve entries in the general ledger for the Trump organization. We have heard a lot about those ledgers involving the Trump organization in prior cases, including cases pending previously before Judge Juan Merchan, who is in fact presiding over this criminal case in which Donald Trump is accused of violating New York law. Now, the matter is here before the court and before the jury, which we're going to talk about, plainly involve a number of different legal issues as well. Falsifying business records in New York State can be a misdemeanor. And by misdemeanor, I mean, of course, offenses that are punishable by imprisonment for less than 1 year. But it can also be elevated under New York state law to a felony if the prosecutors are able to establish that the records in this case were falsified to conceal another crime related to the first one, that is, these business record falsifications. And in this case, there are 3 potential areas where these additional crimes might be advanced, might be articulated, and to some extent established in the trial coming up in that New York courtroom. The DA there has accused Donald Trump of concealing in various ways in 3 different possible other criminal pieces of conduct. One is a federal campaign finance violation. Second would be a state election law crime. And third would be a tax fraud. The campaign crimes, prosecutors are saying, involve directly these hush money payments to Daniels and to another woman named Karen McDougal. The payments, they would argue, were illegal donations to the Trump campaign. The potential tax fraud stems from the way in which Cohen was reimbursed for his payment to Daniels. All of that sounds fairly wonky, quite legal, but it's an important issue because it's going to come up during the course of the trial. That is this attempt, probably successful by the prosecution, to bring what would otherwise be a series of misdemeanor charges into the felony realm and therefore elevate the possible exposure of Donald Trump when it comes to a conviction, if indeed that happens. Let's talk about that just a little bit as well. The charges against Donald Trump are all Class E felonies, if indeed they go in that direction. The lowest category of felonies in New York are Class E felonies. Each one of those carries a maximum prison sentence of 4 years. Each one of the 34, 4 years. Now, if there is a conviction here, it is highly unlikely that this defendant, Donald Trump, at the hands, at the direction of Juan Merchan, the presiding judge, would receive a sentence anywhere near that amount of time, 34 times 4. However, it indicates the seriousness not only of the offense conduct, but the charges that are brought along the way. And again, there are many, many avenues which we may end up talking about here on Amicus, a Law Review, down the road, probably into the month of June, if indeed there is a criminal conviction of former President Donald Trump in the wake of jury selection and in the wake of the jury deliberation. We always hasten to add on this broadcast, as we talk about the rule of law and the administration of justice, that indeed, any defendant, including Donald Trump, is presumed innocent. He is presumed innocent this weekend before the beginning of the trial. He is presumed innocent throughout every minute, every hour of the trial, until that time, if ever, as the jury returns a unanimous verdict finding him guilty of one or more, could be all the counts, could be no counts, but a unanimous verdict in one way or another with respect to the criminal charges pending against him in the state court. More on what's happening with respect to jury selection as we continue in our weekend broadcast.
Are fighting traffic on the interstates. This is The Shaw, 540 AM and 101.1 FM, WAUK.
CBS News Brief. Israel is bracing for a possible direct attack by Iran. Military spokesperson Rear Admiral Daniel Hagari.
Israel is on high alert. We have increased our readiness to protect Israel from further Iranian aggression. We are also prepared to respond.
Iran has vowed revenge after a deadly Israeli strike on its consulate in Syria. At a mall in Sydney, Australia, a man went on a rampage with a knife.
We saw the guy come up the escalators with a big black knife in his hand. And just really calmly, he was just walking like he was having an ice cream in the park.
6 are dead. The attacker was shot by police. Days after the Arizona Supreme Court upheld an abortion ban that dates back to the 1800s, Vice President Harris was in Tucson talking reproductive rights.
We all know if Donald Trump gets the chance, he will sign a national abortion ban.
CBS News Brief. I'm Stacey Lynn.
Your news, conversations, and a whole lot of fun. It's all on your local Civic Media radio station or the Civic Media app.
The Bucks lose to the Thunder. Hi, I'm Mike Clemens with sports. The Bucks were without Giannis and Damian Lillard. They lost to the Thunder in Oklahoma City. The final 125-107. Bucks head coach Doc Rivers.
Yeah, I thought early on we were pretty good. I thought the second quarter we started trying to make too many guys are making plays that shouldn't try to make plays, and we turned the ball over. First quarter, I loved the ball movement. We played downhill a lot. We played to our bigs. We moved the ball, and it was good basketball. Then after that, it looked like guys, everybody who grabbed grabbed it, tried to make a play, and it's just not who most of them were. But, we got a good burn, which I thought was, would love that one, but I wanted to burn some minutes, and we did that.
The Bucks could still clinch the number 2 seed in the conference with a win tomorrow in Orlando against the Magic as the final game of the regular season. Baseball, the Brewers cruised to an 11-1 win over the Orioles. At 9-3, Milwaukee in first place in the NL Central. The series continues in Baltimore. With sports, I'm Mike Clemens.
This is your hometown radio, refreshed, keeping you informed, entertained, and connected locally across the Civic Media Network.
I'm meteorologist Mace Michaels. Lots of sunshine and mild today with highs in the mid-60s. A partly cloudy sky tonight, a little breezy, lows into the low 50s. And sunshine continues Sunday, highs to the upper 60s. Partly cloudy and low 60s on Monday. Currently 40 degrees.
The Todd Alba Show.
Who do you want making the decisions for your daughters if you're a girl dad? I have 2 girls, 14 and 12, and I still consider myself pro-life. But here's the thing. I became a conservative because I didn't want government telling me what to do and being intrusive in my life. And I'll be damned if I want a bunch of theocrats getting in the middle of my daughter's life.
The Todd Alba Show. Weekdays noon till 2 on your local Civic Media radio station and on the app.
Are you prepared for an emergency or disaster? Because it's not a matter of if, but when. Don't find yourself saying,
when the storm rolls in, my time to find a pet-friendly evacuation center will have run out.
The scorching heat wave will leave me powerless to cool my insulin.
I'll face a hurricane without meds. Now that's a tough pill to swallow.
Let's prepare so we all have a better story to tell. Get started at ready.gov/older adults. Brought to you by FEMA and the Ad Council.
Matt and Air on Air.
Welcoming Arizona to the 1860s. Arizona's highest court upheld an 1864 law. Physicians are now on notice that all abortions except those necessary to save a woman's life are illegal. When do we decide she is sick enough or close enough to death that I need to do this procedure to save her life? None of that is codified.
Matt and Air on Air. Weekdays 10 till noon on your local Civic Media radio station and on the app.
Fear you may be missing out? We're always streaming on TuneIn and the Civic Media app. Enjoy listening live or catch up by finding the podcast at civicmedia.us or wherever you enjoy listening to your podcasts. You are listening to your local Civic Media radio station on air. Thank you. Did you know we are always streaming on TuneIn and the Civic Media app too? And if you miss a show or game, find it wherever you get your podcasts or on our website, civicmedia.us.
Broadcasting to Waukesha at 101.1 FM. Broadcasting to Southeast Wisconsin at 540 AM. This is The Shaw, WAUK.
Welcome once again to this, our weekend venue broadcast. My name is Jim Santelle. I am your host this hour and also next hour on Amicus Law Review. We are talking this weekend about the forthcoming trial. The first time in our nation's history that a former president has been put on trial will start beginning on Monday in the courtroom of a judge. Actually, they call them justices in New York. Justice Juan Merchan. I'm going to spend some time right now talking about what he has already done, the things he has confronted just this past week in anticipation of the trial, and what he's going to be doing probably for most of the coming week when it comes to jury selection. We're going to get some insights on this broadcast about how he's going to do that and specifically what questions he is going to be asking members of what's called the veneer, the pool of people called in. About 500 people perhaps have received subpoenas, summonses to come in to the court to begin this jury selection process in the days just ahead. Now, right before the start of the trial on Monday, as you well know from watching the news, Donald Trump, through his attorneys, have filed repeated petitions in various courts, various mechanisms to try to stop the trial. By my count, at least 3 attempts during the course of the past several days to keep this trial from going ahead in front of Judge Juan Merchan. A single appellate court judge, her name is Ellen Gesmer, rejected Mr. Trump's request, among other things. And in addition to that, of course, Donald Trump, through his attorneys, also seeking appellate review of the decision to go ahead now on Monday. That continues as late as yesterday, when the judge in this case, again, his name is Juan Merchan, had before him the former president's latest request to postpone his trial because of publicity about the case in this latest string of delay denials that Donald Trump has gotten from various courts this week. Judge Merchan has already expeditiously resolved that and said, no, we're going to go ahead on Monday with jury selection. Among other things, Donald Trump's lawyers had argued that the jury pool was deluged with what the defense saw was an exceptionally prejudicial news coverage of the case. And the defense, again, on behalf of Donald Trump, maintained that that was a reason to hold off the case indefinitely. Well, Juan Merchan would have none of that. He wrote that Donald Trump appears to take the position that his situation and this case are unique and that the pretrial publicity will never subside. However, this view does not align with reality. The judge went on to say this. He pointed to Trump's 2 federal defamation trials and a state civil fraud trial in Manhattan, which we've talked about here on this broadcast within the past year alone. He wrote that the ex-president himself was personally responsible for generating much, if not most, of the surrounding publicity with his public statements outside those courtrooms and on social media. The situation, the judge went on to say, that the defendant finds himself in now is not new to him, and at least in part of his own doing. He said questioning prospective jurors would address any concerns about their ability to be fair and impartial. And indeed, we're going to spend much of this hour talking about that process. The case now going ahead, presumably on Monday morning with jury selection. One other matter before we get to that as well. One other important thing that Judge Merchan has done as a part of the pretrial disposition of this case, and that is he has ordered what the media and many people call a gag order. That's the last time you're going to hear me use that G word, because in fact, as I mentioned before, no one is being gagged from doing anything, and that's it. We're going to talk about this instead as an order that applies to every defendant in every criminal case in the state and federal courts of our land, that requires that they not do things to affect the administration of justice, the rule of law, in the delivery of justice in the trial. And that means you don't attack the witnesses, you don't attack members of the jury, you don't attack members of the court staff. And Judge Merchan has entered what's called one of these pretrial orders, telling this defendant, Donald Trump, what every other defendant in America is also understood to be under restrictions for, and that is not to do those kinds of things. And indeed, in the wake of Donald Trump's posting some things about the judge's own daughter, the order, again, articulating these standard requirements of every defendant in our country, the judge was obliged to add to that order a restriction, a limitation on attacks upon the families of those people also affected. Interestingly, in the order, the pretrial order, the judge excludes himself, the court, the judge himself, and also excludes Alvin Bragg, the prosecutor, and so presumably permitting Donald Trump to comment and say what he will about the judge and the prosecutor, but no one else. And indeed, interestingly, in the wake of even that amendment to that order, that legitimate, appropriate order to ensure the trial proceeds with due process, equal protection, all of those other things that are guaranteed by our laws and our Constitution, in a post on Truth Social just this past Wednesday, Donald Trump called his former lawyer, Michael Cohen, who will be one of the principal witnesses, yes, that's right, a witness in this matter, and he also called Stormy Daniels, who will also be a part of the trial presentation here. He called them 2 sleazebags who have, with their lies and misrepresentations, cost our country dearly. Now, Judge Merchan's order didn't give specific examples of what types of statements about witnesses that he was specifically going to ban, but he noted that the order was not intended to prevent the former president from responding to political attacks that might be out there, or otherwise to restrict him in his campaign. What it does do is, from my perspective, prevent him from doing exactly what he did just this past Wednesday and previously as well. Name calling, suggesting these witnesses are incredible, and those issues going directly to the veracity of people involved in the criminal justice system. To my mind, violations of the very order that the judge has imposed upon him and imposed upon any other defendant appearing in Judge Merchan's court, any other judge across the country entertaining criminal charges. It will be interesting to see. And here is my commentary for this morning about this. What the judge does, not only in connection with this most recent statement in the public domain, seemingly in violation of the order, the pretrial order, but anticipating from the course of past proceedings that Donald Trump will continue to engage in this kind of thing in the public domain, perhaps even in the courtroom itself. We saw some of that during the defamation trial, the civil defamation trial involving E. Jean Carroll and her attorneys. If Donald Trump continues to engage in this kind of behavior, plainly violative not only of the express terms of this order, but also about the fundamental understandings that go along with any defense presentation, any prosecution presentation as well, what will Judge Merchan do? He needs to respond because of the deterrent impact upon the proceedings if, in fact, he does not do this, if he does not, in fact, impose some penalties, whether fines or, yes, indeed, there could be some limited imprisonment, some detention in a custodial situation for violating these fundamental understandings now set forth in this order. The judge has before him now, as we all do in America, the jury has before it now, the court staff has before it now, witnesses, everyone involved in this process has before it now, likely the next 2 months of activities in the courtroom and presumably, predictably, also outside of the courtroom. You will not see, absent something extraordinary, the prosecutors engaging in public media presentations during the course of the trial. Now, the judge has said he is not going to restrict Donald Trump in his campaign and even from saying other things about the trial generally. But we will see what Donald Trump says both in the courtroom and outside the courtroom that would arguably be violative of this order. And again, remedies available to Judge Merchan if indeed violations continue. I would argue this weekend, this time on our broadcast, that because of the importance of this to deter future conduct, and frankly, to deter the conduct of any other defendants who might be looking at this and saying that they can get away with this too, for that deterrent impact, very important for Judge Merchan in the days ahead, the weeks ahead, the months ahead, to take some action in response to further violations by this defendant, Donald Trump, as the case proceeds. And we will see, we will monitor, we will take a look at what Judge Merchan does as that kind of inappropriate behavior continues. Now, it is important to understand that Judge Merchan has summoned in, again, as many as 500 people from Manhattan, all residents of Manhattan. He will probably bring them into his courtroom in groups of, say, 50, maybe 100. That's a lot of people in any one courtroom at any one time. And he is going to pursue what's called voir dire. It's French. It means to see, to say. It basically is the process by which trial judges select a jury. And yes, indeed, it involves the parties directly. Those of you who have participated as jurors in a case know well what this is all about. Basically, it is an attempt to try to ensure that the jury that is ultimately impaneled is a jury of peers of the defendant. The due process is protected, that equal protection is ensured, and that the people who are responsible for making the single most important decision, that is the guilt or the innocence, the not guilty status of the defendant, those people are brought in to do this in a way that is justice-based, without any bias, and based exclusively upon the things that they see and they hear and they take in the four corners of the trial. And we're going to get back to that because it's a very, very important notion as Judge Merchan conducts this voir dire, this examination of potential jurors, selects probably somewhere between 13, maybe 14, maybe 15, or even 16 jurors for this panel, so that in the end, 12 of them may deliberate. When Judge Merchan calls groups into his courtroom for the purpose of this voir dire process, beginning on Monday, continuing probably throughout the week, he's going to tell them what the case is about. And here is your preview of what Judge Merchan is going to tell the juries. He's going to tell them this. The allegations are in substance that Donald Trump falsified business records to conceal an agreement with others to unlawfully influence the 2016 presidential election. This is a part of the thing that the judge is going to tell prospective jurors, all the tens, the hundreds of people coming in. He's going to go on to say this. It is alleged that Donald Trump made or caused false business records to hide the true nature of payments made to Michael Cohen by characterizing them as payment for legal services rendered pursuant to a retainer agreement. That's exactly what we just described earlier. The people, that is the state of New York, he will say, allege that in fact those payments were intended to reimburse Michael Cohen for money he, Michael Cohen, paid to Stephanie Clifford. That's the woman who's also known as Stormy Daniels, in the weeks before the presidential election to prevent her from publicly revealing details about a past sexual encounter with Donald Trump. That's what the court is going to tell the jury that this case is all about, to give them some predicate for the questions that he is then going to ask them to respond to. And significantly, the judge is going to reaffirm, as he will repeatedly throughout the trial, that Donald Trump has pleaded not guilty and denies these allegations, and that the presumption of innocence attends him throughout the trial until such time as this jury, once it is impaneled, once it is sworn to do its work, does what it is supposed to do, which is deliberate on the evidence and determine in the end if the government, the state, Alvin Bragg, the DA's office, has met its burden beyond a reasonable doubt to prove one or more of those 34 counts in the indictment against Donald Trump. Now, how is this all going to happen? Well, Judge Merchan in early April issued to them a several-page letter talking about what he's going to do in connection with this voir dire process. In addition to telling the jury panel, the potential members of the jury, all about what this case is about, he's also going to say that now that you heard my preliminary instructions and some basic information, if you have any honest, legitimate, and good faith reason to believe that you cannot serve on this case, or that you cannot be fair and impartial based solely on what you have heard up to now, please let me know now. Please do not wait, he will tell you, the members of the jury, after you have been selected as a jury, to tell me that you cannot serve or that you cannot be fair and impartial. The law gives me much greater discretion to excuse you as prospective jurors now than it does to excuse sworn jurors. And then he goes on to say this, fundamental to any criminal case. He says, having said that, please be advised that simply having work or school or childcare responsibilities alone without more will not suffice to excuse you from jury duty. He was going to tell all of that to the jury. I'm going to say that jury service may be inconvenient, but without more, I cannot excuse you. And then he's going to invite those jurors to identify themselves if they fall in that category of people who simply cannot be fair and impartial because of something in their own constitution, their own intellect. And he will identify them plainly on the record as numbered jurors, not as names. We're going to talk more about the non-identification of that pool of jurors and the specific questions that they're going to be asked by the judge as we continue here on our weekend broadcast, Amicus, a Law Review.
To the Shaw, WAUK. Busted pencils.
We'll keep talking about it because it is an important thing happening in our world and in our culture, whether you're in education or in any field. It's part of your day-to-day right now. Like, hey, what's the role AI is going to play in this?
We give every assignment the kids turn in, we put it through AI detectors. There's no ability for a student to opt out of the surveillance.
Busted Pencils, weeknights at 6 on your local Civic Media radio station and on the Civic Media app. Nightlight with Pete Schwaba.
I'm really excited right now because I've wanted to have this guy on for a while. He is a legendary stand-up comedian. You know him as Tom Dreesen. Tom, welcome to Nightlight.
Pete, it's nice to talk to you. Let me tell you how I became a legend. All my critics are dead.
Did you have anything to do with that? Don't say anything, Tom.
No, I refuse to answer on the grounds it might incriminate me. I'll plead the fifth on it.
Nightlight with Pete Schwaba, weeknights 7 till 9 on your local Civic Media radio station and on the Civic Media app. The Shaw, WAUK.
We are continuing this morning on Amicus Law Review to discuss what's going to be happening in a Manhattan criminal state courtroom beginning on Monday, and that is jury selection in the trial of State of New York versus Donald Trump, this so-called hush money trial that actually is an election interference case based upon all the allegations up to this point. We will see exactly how this trial plays out, but we know that it begins with jury selection. And again, describing the process by which Juan Merchan, the trial judge, is going to be entertaining the possibility of impaneling and seating members of this jury in his courtroom for the conduct of the trial likely to last maybe 6, maybe even 8 weeks. Along the way, the judge has already said some things about what will and will not be disclosed. He is going to direct that the addresses and the business addresses, residential addresses of any prospective jurors or even the sworn jurors not be disclosed into the public domain. Those things will be provided to the attorneys, but not in the public domain. And similarly, their names. We will not know who they are. We will identify them exclusively by numbers, and the judge and the parties will identify them by those numbers as well. And beyond that, the court has said that it will tell the jurors just this. The court and both parties in this matter have agreed that your names will not be publicly disclosed. Your addresses will not be shared with anyone other than counsel for the parties. We are doing this, the judge is going to tell them, to preserve your privacy and to protect your identities from members of the public. You must not draw any inferences in favor of or against either party as a result of this order. Again, plainly Judge Merchan doing this because of concerns about what we have seen in America in other situations. Jurors, the subject of threats, jurors, the subject of intimidation, especially if their names and identifications and their addresses are known. He is attempting as best he can to prevent that from happening. Unlikely he will sequester them unless that will become important and key to the legitimacy of the case. But he is going to impanel a jury of, again, at a minimum, 12, 13, 14, 15 people. The reason why you increase the number beyond the obligatory 12 is just because this is going to be an extended trial. And you want to make certain if somebody becomes ill, if there's something else in their business life, their personal life that prevents them from going ahead, that you've got alternates. You've got people who can remain on the jury, on that jury deliberation prospect in case you have some people who drop off. Ultimately, only 12 people can indeed review the evidence at the close of its presentation. Now, the judge has also said that the court has solicited and taken a look at questions presented by parties for the prosecution, by the state of New York, and also for Donald Trump. And he has come to a decision that he is going to ask them some 42 different questions. That is this entire group appearing before him in the next several days, maybe even a couple of weeks or so. Everybody's going to be asked 42 different questions. Some of them have subsets to them. That's why this is going to take so very long. And it will include lots of things that we know and we see in the regular course of a criminal trial. And that include things like, without telling your address, where do you live? What kinds of areas is the Upper East Side, the Lower West Side? He's going to ask them what you do for a living. Who's your current employer? Are you married? Tell us about your family. What do you like to do in your spare time? What are your advocacy groups or organizations that you belong to? Have you ever served in a jury before? And without telling us the verdict, tell us whether you reached a verdict. That's important because you want to have people, once again, who are able to reach a decision, who have the critical thinking skills to assess evidence during the course of the trial and deliberate with others and come to a decision. Interestingly, he's going to ask, question 10, about what kinds of things they do to get news. He's going to ask them about whether they, for example, review the New York Times, CNN, Facebook, MSN, Fox News, the New York Post, Newsdays, Truth Social, TikTok, USA Today. What do they look at? How do you get your news? He's going to ask them about that. He's going to ask them whether they watch or listen to podcasts. They engage with talk radio significantly. He's going to ask if any of them have been victims of a crime. Important. He's going to ask them a lot about their affiliations, if any, in the past with law enforcement. Do you have a relative, a close friend, who's been employed by a federal, state, or local government, including but not limited to the state of New York? Have you, a relative or a friend, ever been employed in the accounting or finance field? He's going to ask them about that. All these things relevant to issues related to the case itself before the jury. He's going to ask once again about any affiliations, either direct by members of the prospective jury pool there or people who have affiliations through family or friends with the police generally, the FBI, the DA's office, Department of Corrections, all kinds of things related to justice in America. He's going to ask if you've ever had any education, training, or work experience in the legal field as well, including the practice of law, criminal or civil. He's going to ask if you have a relative, a close friend who's ever been accused or convicted of committing a crime. And are there any pending criminal cases that you may be involved in as well? And then significantly, getting into more the heart of this particular case, a number of questions about where they come from, if you will, kind of politically. He's going to ask, do you have any political, moral, intellectual, or religious beliefs or opinions that might prevent you from following the court's instructions on the law, or which might slant your approach to this case? One of many questions that go to this fundamental issue about whether or not jurors can indeed return a verdict based upon what they see exclusively in the courtroom. Do you have any political, moral, intellectual, or religious beliefs or opinions that would interfere with your ability to render a verdict in this criminal case? All those things important to this deliberation. He's going to ask, can you give us assurance that you'll be fair and impartial and not base your decision in this case upon a bias or a prejudice in favor of or against a person who may appear in this trial on account of that person's race or color, national origin, ancestry, gender identity, expression, religion, religious practice, age, disability, sexual orientation, or political views? Can you bring to this deliberation a truly biased approach? And he's going to ask, can you promise to guard against all stereotypes or attitudes about individuals or groups of people referred to as an implicit bias that may influence your decision? Now, in addition to all of this, the court is also then going to narrow in and determine whether or not any members of the potential jury have had any additional involvement with, either directly or derivatively, very derivatively, with Donald Trump, the defendant. Have you, a relative or a close friend, ever worked for any company or organization that is owned or run by Donald Trump or anyone in his family? Are you signed up for? Have you, or are part of the particular kinds of things that Donald Trump posts, for example, on a listserv or a newsletter? All of that, a part of the deliberation that the jurors will be undertaking as they answer these questions. When we continue in our second hour here on Amicus, more about what Judge Merchan is going to be asking these jurors to respond to as he selects a jury in this historic trial beginning on Monday in a Manhattan courtroom. Stay with us for the second hour of our broadcast.
540 AM and 101.1 FM, WAUK.
Coming up Monday on Nat Nair On Air, 3 headlines and a lie, and it's tax day. I hope you'll join us.
It seems like the cost of everything is going up, so it's nice to save a little dough when you can, especially for something you love to eat every day. Before I go grocery shopping, I print out a coupon for $1 off any Country Hearth, Village Hearth, or Artisan Hearth bread product. My favorite is Dakota-style 12 grain. My wife's breakfast go-to is a toasted Village Hearth English muffin. We can save $1 on each. Go to countryhearthbreads.com/coupons and print 1 or 2 out before your next shopping trip. And don't forget, Country Hearth, Village Hearth, and Artisan Hearth bread products are baked locally and delivered fresh daily.
You're listening to The Shaw, WAUK 540 AM Jackson, W266DR Waukesha, and always streaming on the Civic Media app.
This is CBS News on the Hour, sponsored by Clean Origin.
I'm Stacey Lynn. Early this morning, Iran was accused of seizing a commercial ship with links to Israel as it passed through the Strait of Hormuz. The BBC's James Lansdale.
The Israeli Foreign Minister Israel Katz has accused Iran of piracy.
The U.S. and Israel are on high alert for a potential attack by Iran that could escalate regional tensions stoked by the war in Gaza. CBS News Chief Foreign Affairs Correspondent Margaret Brennan.
Since October 7th and the beginning of this war in Israel, the concern has been what could be the event that would spiral this into a regional conflict. Iran and the United States have been sending messages to each other saying neither of us want to escalate this. Israel carrying out that strike inside Syria that killed Iranian generals really was an escalation.
An attack could happen any time now. A shopping mall in Sydney, Australia is the scene of the latest mass attack. A man went on a stabbing rampage. 6 are dead. The suspect was shot and killed by police. This man described the chaos.
I heard people yelling and screaming, running. So I said, okay, there must be something going on. So I saw the copper. I followed her all the way upstairs. Just as we were coming around the corner, there he was. He just come in and just started floating towards us. And then she shot him. She didn't shoot him. Well, he would have kept going. He was on the rampage. He was on the bloody rampage.
Police have no idea of a motive yet. In Texas, a man driving a stolen big rig semi-truck intentionally crashed into a government office building, killing one person and injuring more than a dozen others. Katira Winfrey is with CBS in Houston.
The truck was carrying a heavy load of rebar, steel enforcement, when Parker slammed it into the building where various licensing services are provided. Authorities say he had been there the previous day.
Parker did come to the DPS Brenham office where he was denied his commercial driver license.
The mayor said it could have been even worse had Parker not been pulled out of the driver's seat and put in handcuffs by law enforcement.
Had it not been for their quick action, the suspect was backing the vehicle up and with the intent of going into it again.
O.J. Simpson's brain will be incinerated, not investigated. The New York Post is reporting he's expected to be cremated Tuesday in Las Vegas. And despite multiple requests from scientists, his family has no plans to donate his brain for research. They were asking to study the brain to see if he suffered from CTE, a degenerative brain disease afflicting many retired football players who suffered multiple concussions during their careers. This is CBS News.
Don't pay retail for diamonds. Come to cleanorigin.com, the lab-grown diamond experts. Mention code radio10 for 10% off. CleanORIGIN.com, online or one of our retail stores.
You can always continue the conversation on social media. Share your thoughts when you find and follow Civic Media on Facebook, X, and Instagram.
For Civic Media News, I'm Terry Bell. Wisconsin is having a green energy construction boom. As Mike Moan reports, that's good news for Wisconsin's unionized construction workers.
4 major utilities operating in Wisconsin recently announced a pledge to hire union workers for clean energy development tied to federal incentives under the Inflation Reduction Act. Kent Miller of the Wisconsin Laborers District Council says it paves the way for a smoother transition to more wind, solar, and similar projects.
With the commitment from the utilities to make sure that the wages and benefits are the same standard as legacy energy, it allows workers to focus on updating their skill sets to meet the needs of the project and not worry about are there concessions in wages and benefits.
In earlier phases of renewable energy construction, Miller says some project leaders focused on bringing in out-of-state non-union contractors. Now that Wisconsin labor organizations have a seat at the table, Miller says the next challenge is getting more advance notice before a project breaks ground so they can ramp up recruiting well ahead of time. For example, Miller says a utility-scale solar development requires a lot of labor, and they want as many people as possible to know about potential openings. He says that includes apprenticeships.
Somebody could start their apprenticeship career, complete their apprenticeship, and become a journey worker through the duration of a utility-scale solar project.
He points to the Paris Solar Farm project in Kenosha County, which at its peak had nearly 150 laborers. Of the apprentices, 70% were women or people of color. Analysts say the hiring pledge and associated projects could lead to nearly 19,000 construction jobs that come with prevailing wages. This is Mike Bowen for Wisconsin News Connection.
You're listening to Civic Media News. I'm Terry Bell.
Monday, I'm joined by movie producer Bob Brown and Milwaukee Journal Sentinel reporter Chris Foran. It's Nightlight with Pete Schwaba from 7 to 9 p.m. on the Civic Media Radio Network.
I'm meteorologist Mace Michaels. Lots of sunshine and mild today with highs in the mid-60s. A partly cloudy sky tonight, a little breezy, lows into the low 50s. And sunshine continues Sunday, highs to the upper 60s. Partly cloudy and low 60s on Monday. It's 46 right now.
Keeping Southeast Wisconsin informed, engaged, and entertained. This is The Shaw, 540 AM and 101.1 FM.
This is our broadcast on civic media throughout the state of Wisconsin and beyond. My name is Jim Santelle, your host this hour and every weekend, discussing issues in law and government, the administration of justice in America. This weekend, talking about this major event happening in American history beginning on Monday morning. That is the first time a former president of the United States of America has been placed on trial, this one in a state criminal court in Manhattan, in New York City. And we are talking a lot about the pretrial process by which this case has gotten here, the basic focus of it, the substance of the charges, and discussing what Judge Juan Merchan, who is the presiding judge or justice, as the judges are called in that venue, what he's going to be doing with respect to the selection of a jury, the questions he's going to be asking them to determine whether or not they can be fair and impartial, the things he's going to say to them about what this case is about, and the specific admonition that they are not to bring into the courtroom, at least their deliberation on the courtroom, anything other than their open ears and eyes, their capacity to do critical thinking to determine whether or not the government, as it always is obliged to do, has presented evidence beyond a reasonable doubt in support of the 34 counts or some of them that would justify a verdict of guilty in this matter. Again, Donald Trump presumed innocent until such time as the jury does just that. Who's going to be testifying in the course of the trial? We're planning. We've talked a lot about Michael Cohen. We've talked a lot about Stormy Daniels. There's another fellow named David Pecker, who is the former publisher of the National Enquirer. He's also involved in this with respect to the catch and kill aspect of this case. It's entirely possible that other members of the former Trump administration will also be called in to testify. Hope Hicks, a former campaign and White House aide to Donald Trump, others who, according to the district attorney, also have information that is relevant to this particular transaction or set of transactions that are the focus of the financial charges in this case. But 5 or 6 other people also on that list, names we may have heard of from the Trump administration. No obligation to call everyone on a witness list, but again, an obligation by the prosecution to present evidence. It is the burden of the government to prove the case beyond a reasonable doubt. Defense, Donald Trump has no obligation whatsoever to present any evidence, including testimony of his own. Even so, Donald Trump, in anticipation of this and in reaction to the judge's serial denials of his request for a delay, a number of delays sought by the defense in recent days, he said on Friday that he did in fact plan to testify at this trial. He did call the case and things related to the case administered by Judge Merchan. He called it a scam. He said, all I can do is tell the truth, and the truth is they have no case. Now, again, the defendant does not have to make that particular decision until the judge looks at the defense and says, you may present your case. And even during the course of that presentation, it is up to the defendant whether or not to take the stand. And we will see whether Donald Trump is true to his word about taking the stand. No presumption against him if he does not take the stand. And indeed, prosecutors cannot argue. It is a matter, it would be a mistrial if they were to suggest to the jury that the failure of the defendant to testify should be taken into account by them. The defendant always has his Fifth Amendment right not to testify. That attends to Donald Trump at all times. And about this process called jury selection, Donald Trump said that the process is largely luck. He said it depends on who you get. Well, not entirely. The judge is doing his very best in this very human enterprise to try to determine exactly who those jurors would be, and continuing our discussion about the kinds of things that the jurors are going to be asked on Monday and Tuesday and throughout the weekend, probably into the following week as well, as this entire veneer, the entire group of jurors is called in and asked some 42 different questions about who they are, their background, along the way, focusing specifically upon Donald Trump and the allegations in this case. The judge is going to ask them some things that I do find interesting. He's going to ask them, have you ever considered yourself a supporter of or belong to any of the following? the QAnon movement, Proud Boys, the Oath Keepers, the Three Percenters, the Boogaloo Boys, or Antifa. All those groups in various ways we've talked a lot about on this broadcast, in previous broadcasts. Some of them the subjects, obviously, of criminal prosecutions and convictions and sentences for things related to the January 6th matter in 2021. This case, of course, harkens back to the days right before and after the 2016 election and into 2017, related again to the alleged violation of the financial laws in the state of New York. Interesting that the justice, is going to be asking about affiliations or support to any of these groups. Interesting as well, question 31, do you have any strong opinions or firmly held beliefs about whether a former president may be criminally charged in state court? Sort of asking almost a legal question of the jurors and whether they have any strong opinions about that sort of jurisdictional, that power, that capacity argument. Do you have any feelings or opinions about how Donald Trump is being treated in this case? Obviously, the judge responding in some ways to the things that are out there in the media. Donald Trump maintaining, as he did as late as this past week, that he is being treated unfairly, not only in the decision not to grant these delays, but in other matters related to pretrial dispositions. And once again, the judge asking repeatedly during the course of these 42 questions, can you assure us that you will decide this case solely on the evidence you see and hear in the courtroom and the law as I give it to you? Significantly, do you have any strong opinions or firmly held beliefs about Donald Trump or the fact that he's a current candidate for president that would interfere with your ability to be fair and impartial? He's going to ask if you read or listened to any of the books written by Michael Cohen. He's also going to ask about any books that the members of the jury pool have read that the defendant himself has written, Donald Trump has written. If so, which ones are those? And significantly, do you have any opinions about the legal limits governing political contributions, an issue not really related specifically to this case, but unless the judge determined that somehow that is important to know. Again, not asking what those opinions are necessarily. That might be a follow-up, but do you have any opinions about that? And once again, can you promise to set aside anything you have heard or read about in this case and render your verdict solely on the evidence presented in this courtroom and the law as given to you by me, by the judge? Can you do that? Can you separate out any biases, any sorts of prejudices and preconceptions that you have, and make your determination based exclusively on what you see, what you hear, what you consume in this trial? Can you assure me, the judge will be saying, that you will follow my instructions and on the definition of reasonable doubt and the presumption of innocence, once again, that attends this defendant? The Constitution, he will tell the members of the jury, provides the defendant has no burden to introduce any evidence or testify in any criminal case. Do you understand that? And will you not impute anything to the defendant if the defendant chooses not to go down that road? In the end, number 42, is there any reason, would it be bias or anything else, that would prevent you from being fair and impartial if you are selected as a jury for this case? Lots and lots of things for jurors among a group, probably about 500 people coming in groups of maybe 50, maybe 100, maybe something more, something less. Ask those questions to determine whether or not they should be impaneled. The process itself, the judge himself will probably strike for what's called cause. Those jurors who indicate either initially or during the course of this colloquy, this conversation back and forth, will determine whether or not some of them should be stricken because they simply cannot do this job. And then after he has determined that something less than that total group of 500 or several hundred or whatever it may be, then the parties themselves have the capacity through a process that he will also describe to strike witnesses, to strike jurors rather, to strike jurors from this process, from the lists that are then presented to them based upon things that they have heard during the course of this voir dire. That process, again, going to take a number of days, maybe even into early the following week before the judge can have them all stand, raise their right hands, and promise, commit, swear to hear the evidence in this case and to invest in it all of their good judgment, all of their good assessment, the critical skills, thinking that they need to apply to all of this, and render a true and just verdict based upon their impartial views about this. Now, this goes to a larger question that I suspect is out there a lot, that many of us are pondering, which is, can that happen? And Donald Trump has already said, even despite his fairly benign comment about the jury just on Friday. Donald Trump, nonetheless, has said that he cannot get a fair trial in this nation because he is so famous and maybe even notorious. His attorneys have said the same thing. And the answer to the question is, of course, we're not looking to impanel, to place on the jury members of a jury who know nothing about Donald Trump. In fact, if you've got people who say that, probably you don't want them on the jury because they don't have that interest in the world, interest in the community in which they live. You want to find people who can understand who this is. They certainly will appreciate that he is running for the presidency. They certainly will appreciate that he is a former president, that he is a public figure of the highest order. The question is, with all of that, can you set that aside, whatever your biases are, and nonetheless make a determination based upon whether or not the government has proven its case beyond a reasonable doubt? That is the question. And my experience of 30 years is that jurors can indeed do that. Not everybody can, and that's the reason why you strike them. The judge would eliminate them for cause. But those who continue in this process, I believe, who have the critical thinking skills to do this job as they should, do in fact have the capacity to do just that. And we will see what Judge Merchan does in finally selecting a jury, again, probably of more than 12 people, perhaps as many as 14, 16 people, to ensure the vitality of that jury as it continues in 6 to 8 weeks of trial. As always, we appreciate our callers. Those people are texting as well. Joe, you're calling in from Madison this morning. Appreciate, as always, your comments, your inquiries about our subject matter on our weekend broadcast.
This is wonderful. I appreciate all the information very much. I'm curious to get your reaction to the problems that the judge faces within this trial. It seems to me, and I'd be curious to hear what your reaction is to this, that we have this person who is coming up before him in trial who is, I'm sorry, a private citizen. He's not president. And the fact that he's ex-president, one could certainly argue, so what? Or the fact that he's running for office, so what? A lot of people are running for office. It seems that the judge has a situation where if deference is given to Mr. Trump in this particular situation because of he is an ex-president or because he's running for office, then you're in a situation where anyone can be claiming that who is running for office. Or if you have a current senator who's up for charges or a current governor who's up for charges, that it seems that this judge is in a circumstance because of this. He's in a situation where he can be creating precedent in terms of how do you treat people who are running for office, highly public figures in the political world, in order that it seems fair and that you're
absolutely,
Joe.
Because it's not. And great comments, and I'm going to take up the answer to that as our Saturday morning and weekend broadcast continues here on these broadcast stations of Civic Media.
You're listening to The Shaw, WAUK, Waukesha's home for Matt and Air on Air.
Most of us can agree the decision to have an abortion should be between a person and their doctor. Politicians should have no say at all. Thankfully, Senator Tammy Baldwin is standing up for our rights and working to keep politicians out of our medical decisions. After Roe v. Wade, the court case that protected abortion rights, was overturned, Tammy Baldwin introduced the Women's Health Protection Act, which would ensure access to abortion everywhere in the United States, including here in Wisconsin. The bill would end extreme abortion bans that have no exceptions for rape, incest, or the life of the mother, and threaten doctors with criminal charges for providing abortion care. Senator Baldwin also introduced legislation that would protect the right to travel across state lines for reproductive health care and safeguard access to contraception. Call Senator Tammy Baldwin at 202-224-5653. Tell her thank you for fighting back against extreme abortion bans. Paid for by A Better Wisconsin Together, Inc.
This is The Shaw, WAUK.
This is our weekend broadcast here on the stations of Civic Media, broadcast throughout the state of Wisconsin and beyond. Appreciate, as always, calls and texts calling in, 844-967-2789. Recently taking the very good comment and question made by listener and caller Joe, who is wondering about the precedent that Judge Merchan may be setting when it comes to giving, as she said, any deference to this particular defendant, who is one of many defendants in cases throughout the United States of America. Right now, as Joe observed, he is not holding official office. And for that reason, what kinds of things does the judge need to be concerned about, not only in asking questions, but plainly, I would say, Joe, beyond that, in treating Donald Trump in a way that should be different, if at all, from any other defendant? And I think that's what your question goes to. Indeed, the judge has said in the past, as have other judges, specifically Tanya Chutkan and other judges who are presiding over similar cases involving Donald Trump, that recognizing that, yes, indeed, he is Donald Trump, he is known generally, and he is in a campaign trail, all of them have said a couple of very important things. One is that no one is above the law, and that is a fundamental notion that the Supreme Court is also hopefully not wrestling with, but hopefully will simply affirm in June when it comes to these immunity arguments and other things. But also that when it comes to this courtroom proceeding, the judges, including Judge Merchan, as he has said, will treat this defendant as he would any other defendant. That's my comments about this order also that he has imposed and then expanded to ensure that none of the comments that the defendant makes are contrary to the administration of justice. Comments about the legitimacy, the veracity, the truth, the credibility of witnesses, for example, or even the conduct of jurors, all those kinds of things, not appropriate for any defendant, including this one. And yet, the judge has indicated he is going to be raising this issue of public notoriety in the jury selection process, the voir dire process, as Joe indicated, and wrestling, if you will, with the balance between a person who does have this public notoriety and someone who is also treated as any other defendant would be treated. It is a difficult job to do. There's no doubt that Donald Trump is not entitled to any special deference. He is not entitled to any deference when it comes to evidentiary rulings, to considerations about what may happen. And indeed, one of those areas is that in a criminal trial, as opposed to a civil trial, the defendant needs to be there physically in the courtroom. Now, the judge has said that probably is going to take Wednesdays off during the course of the next 6 to 8 weeks or so give everybody a chance to do other things, including him, perhaps. He's got other matters on his docket as well. But when the courtroom is in session, the jurors need to be there, the court staff needs to be there, the judge needs to be there, the prosecutors need to be there, the defense counsel needs to be there, and yes, indeed, the defendant needs to be there also. So it's entirely possible that at some point, this defendant, Donald Trump, will say, I've got to be out there campaigning. My strong sense from hearing from Judge Merchan in the past is that he will take that argument in and deny any request for consideration for deference when it comes to being on the campaign trail. And also when it comes to the basic administration of justice, as I said, the evidence says it comes in. While you want to know that for purposes of placing jurors in that jury box, the fact that this happens to be a present and perhaps future president should not have an implication for the deliberation the jury undertakes. And I suspect in the final instructions given by this judge to the jury before it goes into deliberation, this judge will say just that. All great comments. This is plainly a significant trial at the same time, should partake, and Joe's comment goes to this fundamental notion, it should partake of any other criminal case, even though in our history and in terms of the status of it, it gets media coverage beyond virtually anything we have seen before, at least in recent times. We will continue to monitor all of this, including the conduct of jury selection. My sense is that even when we are back on the air next weekend here on Amicus, a law review, that process may well have been just concluded, maybe just about concluded, or maybe even continuing, because it will take a long time to seat a jury. But nonetheless, the important takeaway from this extended discussion this morning, our microscopic look, if you will, about what's going to happen in the coming days, is that this process is possible. And although Donald Trump may raise it on appeal, if in fact he is convicted, the reality is it is possible. It is possible to identify jurors, even from Manhattan, who can, in fact, set aside those things that may be in their brains, in their histories, in their backgrounds, and make a determination based upon the evidence in the courtroom presented by the government about whether or not there is proof beyond a reasonable doubt of the commission of these 34 different acts set forth in the indictment. A lot to take in, a lot of legal issues, a lot of factual issues, a lot of process here discussed on Amicus, a law review, and continuing as always to take your questions and comments here on our weekend broadcast. I promised at the start that in addition to discussing this major issue, this major historical event coming on Monday, we would also talk about two other issues important to the conduct of the present campaign, not just for the presidency. Certainly it is central to that, but also about campaigns across our nation for local, state, and other governmental offices. And that has to do with firearms in America. We have talked a lot about firearms in America on this broadcast in previous renditions of it. This weekend, no exception at all. 3, maybe even 4 major things happening just this past couple of weeks or so, including the past several days, just this past week before our weekend broadcast, having to do with guns in America, the way that guns interact with government, and the way that courts respond to instances of violence. We know about the mass shootings that continue to populate and terrorize our nation on a regular basis. This past week, a number of different news stories in the area of rule of law, important to underscore when it comes to trying to address the huge challenge that we have in our nation here in the state of Wisconsin, having to do with the fueling of gun violence. The Biden administration just this past week approved what has to be called the broadest expansion of federal background checks in decades, doing that in an attempt to regulate this fast-growing shadow market of weapons, we sometimes call it, that are sold online, sometimes at gun shows, through private sellers that have contributed, from my perspective, in many ways to gun violence. Under a rule that was released just this past week, on Thursday of this past week, the Bureau of Alcohol, Tobacco, Firearms, and Explosives, the ATF, will now require that anyone who is engaged in the business of selling guns at a profit, anybody who does that has to register as a federally licensed firearms dealer, sometimes called an FFL. Dealt with that a lot when I was doing criminal prosecutions of firearms cases in the federal district court in the Eastern District of Wisconsin. That basically means that those sellers must run background criminal and mental health checks on potential buyers. That obligation, of course, also imposed, as it has been for many years, on legitimate sellers of guns in institutions recognized by the EF. The new regulation, likely to face legal challenges, undeniably going into the courts, could add as many as 23,000 federal dealers to about 80,000 already regulated by the ATF. And that rule, which drew more than about 380,000 public comments, will take effect in about a month from now. And again, challenges coming up in the times just ahead. In our continuing discussion here on our weekend broadcast, talk more about what this means and talk more about guns in America as we continue our discussion of all things rule of law and justice in our nation.
Your home of the Earl Ingram Show, weekday mornings from 8 till 10 on The Shaw, 540 AM and 101.1 FM WAUK.
Direct attack by Iran. Military spokesperson Rear Admiral Daniel Hagari.
Israel is on high alert. We have increased our readiness to protect Israel from further Iranian aggression. We are also prepared to respond.
Iran has vowed revenge after a deadly Israeli strike on its consulate in Syria. At a mall in Sydney, Australia, a man went on a rampage with a knife.
We saw the guy come up the escalators with a big black knife in his hand. And just really calmly, he was just walking like he was having an ice cream in the park.
6 are dead. The attacker was shot by police. Days after the Arizona Supreme Court upheld an abortion ban that dates back to the 1800s, Vice President Harris was in Tucson talking reproductive rights.
We all know if Donald Trump gets the chance, he will sign a national abortion ban.
CBS News Brief. I'm Stacey Lynn.
Enjoying this local program? Find the complete Civic Media lineup at civicmedia.us or the Civic Media app.
The Brewers clobber Baltimore. Hi, I'm Mike Clemens with sports. The Brewers jumped out to an early lead. Top of the second, Gary Sanchez went yard at Camden Yards.
Here's Gary Sanchez looking for his first hit of the season. Sanchez drills one deep left field. That is trouble. It is gone. A two-run homer for Gary Sanchez, and the Brewers are up 2-0.
Valley Sports Wisconsin. The final, the Brewers 11-1 over the Orioles. Home runs for the Brewers: Sanchez, Willie Adames, and William Contreras. Christian Yelich left the game early with a sore back. The series continues in Baltimore. NBA, the Bucks' Damian Lillard sat out last night's game against the Thunder. Milwaukee ended up losing 125-107. NFL, the Packers tailgate tour continues in Madison and Oshkosh with a new 4-3 defense. I asked Kenny Clark, do you think he'll be playing more inside?
Yeah, definitely. I'm gonna be inside for sure. If it's 3-tech or nose, I don't know yet. I could play anywhere though.
That's Packers defensive lineman Kenny Clark. With sports, I'm Mike Clemens.
I'm meteorologist Mace Michaels. Lots of sunshine and mild today with highs in the mid-60s. A partly cloudy sky tonight, a little breezy, lows into the low 50s. And sunshine continues Sunday, highs to the upper 60s. Partly cloudy and low 60s on Monday. It's 46 right now.
It's 2024 and Worthington, Minnesota continues to shine. We've expanded so many things. It's a time of growth. We've expanded recreation activities with our indoor ice arena, our indoor turf rec center and playground, and our outdoor water park, Waterworld, is ready for another season. Our schools have expanded, and so has our industry. We're continuing to expand our population also, with lots ready to build on Glenwood Heights. So let's grow together in Worthington, Minnesota. It's worth a look.
Hey, folks, how you doing? It's me, Charlie Behrens, and I want to let you know that I'm coming to the Wisconsin State Fair main stage presented by Potawatomi Casino Hotel. We got tickets on sale over at wistatefair.com, and I'm bringing free brandy for everyone. Unless for some reason I can't, then, sorry in advance. Anyways, I will see you at the Wisconsin State Fair presented by U.S. Cellular on August 8th. Real good. Bye-bye now.
Keeping you informed, entertained, and connected to your local community. Here's Terry Barr with the Civic Media Radio Network.
The dreams of a Greenfield girl are documented in the new film, Angels of Dirt. Wisconsin-based director Wendy Schneider says Charlotte Keynes caught her eye as a tiny motorcycle racer.
These young girls racing and was very intrigued with their tenacity and their dedication to the sport.
Schneider filmed the girls' races for years, and Keynes' dream to turn pro came true in her teens. But she died after an on-track crash.
For me, I've been working on this film before she passed away. Her life and her footage lived through the work that I was doing. So I think there's a big healing that comes with this film.
Learn more about this beautiful tribute to Keynes at angelsofdirt.com. Until next time, I'm Terry Barr.
Waukesha, home of Les Paul, our awesome farmers market, and The Shaw, 540 AM and 101.1 FM.
Thank you for your continuing listening in our weekend broadcast, our weekend venue broadcast about all things rule of law related, talking this morning in our last segments about two other important issues in not only the campaign going ahead for the presidency and for other offices in America, those issues having to do with guns in America and abortion in America, but also spending most of our first hour chatting about what's going to be happening in a courtroom beginning on Monday in Manhattan. That is jury selection. In the first time in our nation's history that a former president placed on criminal trial for conduct that he allegedly engaged in, presumed innocent, involving violations allegedly of New York state law. We'll continue to monitor that and continuing to monitor issues related, of course, to guns in America. As we continue to understand what the Second Amendment means, we know that the Supreme Court has, in past terms, made some very important decisions in connection with the understanding of the Second Amendment, permitting the constitutional ownership and presumably use for defensive purposes of a handgun, a firearm, for self-defensive purposes in the home, and expanding that more recently to include places in the public domain as well. And a case called Bruin, setting forth a test that may be difficult to address in the future, already is posing some challenges that would test the legitimacy of attempts to control gun sales, manufacturers, transfer, based upon whether or not that particular legislation, that rule, does in fact comport with history. Things that the country legislatures have done in the past. That's the Bruin test. And indeed, probably going to be the subject of attacks upon what happened just this past week with the Biden administration establishing through the ATF this new rule. It is effectively an executive order that requires anyone engaging in the business of selling guns at a profit to register as a federally licensed firearms dealer, therefore to be under the rubric, under the control, if you will, when it comes to the mechanisms by which sales are made of the ATF. Kamala Harris, who is leading the White House efforts on the election year issues related to gun policy, told reporters on Wednesday the new regulation addressed one of the biggest gaps in the federal background check system. And again, yes, indeed, it has. The single gap, she said, in our federal background check system has caused unimaginable pain and suffering. She also noted that gun violence was now the leading cause of death among children. This particular rule, of course, going to be administered by Steve Dettelbach. Steve Dettelbach, a former colleague of mine, former U.S. attorney in Ohio, also during the Obama administration, know him well. He is a terrific public servant, lifelong public servant. He, among others, is the first director of the ATF in recent years to be confirmed by the Senate. He is there now as that important role goes forward. He is going to be responsible for administering this rule and making referrals of those people who may choose to violate the rule, where? To the Department of Justice for prosecution. Indeed, failing to register under this new rule carries a penalty of up to 5 years in prison and a $250,000 in fines. Steve Dettelbach, the head of the ATF, responsible for this new rule, certainly going to be the subject of a lot of litigation, challenging it under the Second Amendment in the wake of the Supreme Court's cases in Bruin and other matters, even preceding that Bruin case. We will continue to monitor that, as well as we'd also think about things going on in other courts, some significant events, some events happening just in the courts this past week or so. We know that Jennifer and James Crumbley, convicted previously of involuntary manslaughter for failing to prevent their teenage son from killing 4 fellow students in what is plainly the deadliest school shooting in Michigan's history. Both of them, the Crumbleys, the parents of this young man, were sentenced just on Tuesday this past week to 10 to 15 years in prison. Their separate jury trials, we talked a lot about that on this broadcast, ended in guilty verdicts in February and March. They were tried separately. And it makes them the first parents in our country, to be convicted over the deaths caused by their child in a mass shooting. Now, involuntary manslaughter in Michigan carries a penalty of up to 15 years in prison. Prosecutors asked in some sentencing memorandums presented to the judge, filed in the court prior to the sentencing, that each of them serve at least 10 years. Both have been in jail for more than 2 years while awaiting trial, and they, of course, will receive credit for their time served. And, of course, this issue, this matter of finally the sentences imposed upon the Crumbleys, raised this increasing focus on the attempts by prosecutors, maybe by the government generally, maybe by communities generally, to hold responsible those people who may be in some way contributing, thus the charge of involuntary manslaughter, to these mass shootings. And it is controversial, there's no doubt about it, but it also indicates that we are continuing to address this major problem in our nation in ways we have not previously done that before. The Crumbleys' son, Ethan, you may recall, he was 15 when he carried out this shooting, killed Justin and Hannah, as well as Madison Baldwin and Tate Myrie. 7 others were injured. Ethan Crumbley previously pled guilty to 24 charges. That included first-degree murder, and was sentenced last year to life in prison without parole. He is still eligible to appeal that decision. His parents may appeal those decisions as well. That is their right under our system. Pursue that, and to determine whether or not an appellate court would in any way address matters related to the trials and the sentences imposed upon them. All of that, all a part of our continuing discussion in America, both in courts and outside courts, about the circumstances under which individuals who themselves are not firing the weapons are responsible for putting people in places, namely their minor children, most often young men, who engage in these horrific events in our nation's history. Now, an awful lot of people say, well, gee, if you open up this particular door and go down this road, if you will, to mix some metaphors there, if you do that, you're exposing all parents then, and maybe all administrators too, all teachers, the possibility of criminal prosecution. And I would offer that that is not the case. In this particular case involving the Michigan parents, you had some wildly aggravating circumstances involving their knowledge of what their young son had done, the kinds of warnings that they'd gotten on that day, the kinds of things they should have known about, that were all presented that during the course of the trial, concluding with the fundamental determination by the jury that the tragedy completely preventable if only these parents had done something. That is not the case in many other situations where parents may have had some inkling or maybe no inkling at all that their young charges, their children may have been involved or might be involved in mass shootings of this course. And of course, only in a criminal court do you have to establish beyond a reasonable doubt that someone is guilty of the offense conduct charge. I do not view these particular prosecutions in Michigan and others as opening up a box that cannot be closed, still requiring an awful lot of proof that the individual defendants knew about the threat posed by their children, knew about the danger posed to other students and perhaps teachers, administrators as well, purposely failed to do nothing about it, and ignored as the trial evidence showed that the events were about to happen. It is still a very high bar, and I do not believe it will open up exposure in many other ways that would otherwise not be available. But we do have another instance just this past week of another case being initiated, this time in Newport News, Virginia. A former assistant principal in a Virginia elementary school there, where a 6-year-old boy shot his teacher last year, you may recall this well, has been indicted there in Virginia on 8 felony counts of child abuse and neglect. And that, according to some court documents that were unsealed just this past week. The former assistant principal, her name is Ebony Parker. She was indicted again by a grand jury. What did they do? They found there was probable cause to believe that, in fact, the elements of the offense had been committed, not proof beyond a reasonable doubt. That's what a trial jury judged. But they returned this grand jury indictment, making these 8 felony counts of child abuse and neglect a part of the public record. Each charge carries a maximum sentence of 5 years in prison. Now, last year, the Newport News Commonwealth's attorney, the government attorney there, had asked for a special grand jury to investigate some security failures that may have, in fact, contributed to the Rich Neck Elementary School disaster there, the shooting, and determines whether others were criminally responsible for that conduct. His office, of course, then pursued that, and these charges against Ebony Parker are the result of that grand jury inquiry at a time, as I indicated, when adults, in one case, parents in Michigan now, school administrators, increasingly being held accountable in cases where juveniles have caused this gun violence. The mother of the 6-year-old boy, Deja Taylor, was sentenced in December to 2 years in prison after pleading guilty to felony child neglect. And earlier, she was sentenced to 21 months after pleading guilty to using marijuana while owning a firearm and making false statements about her drug use. The indictment against Ms. Parker was unsealed on, again, the same day that the 2 parents in Michigan were sentenced to 10 to 15 years in prison for failing to prevent their son, in that case, from killing 4 students in the deadliest school shooting in that state's history, the subject that we just now talked about. Now, all of this again comes in the midst of this so-called new avenue being explored by prosecutors who are bringing criminal cases against individuals who may in fact be responsible. The case involving Ebony Parker, as we always do, presumed innocent until proven guilty, and that innocence attends her throughout the trial. But again, a trend that is both notable and significant as we attempt, perhaps haltingly, perhaps imperfectly to address gun violence in America, but nonetheless identify these avenues for attacking this problem in a way that brings these issues back into courts, and recognizing once again that there are necessarily going to be limits on that process as well. Still need to show intent in a criminal case, still need to show, even in a charge of abuse and neglect, the basic elements of that offense in order to establish to a jury, beyond a reasonable doubt, that indeed this offense conduct has been pursued and accomplished by the identified defendant. Finally, in the area of firearms, generally, we know that on Monday, the same day that we have other significant things going on in Manhattan and beyond in that week, we know that on Monday, the state legislature in the state of Tennessee is going to be taking up a bill that allows Tennessee public schools school teachers the capacity to carry firearms on school grounds. The Tennessee Senate had previously passed this fairly controversial measure, and they sent the bill to the State House, and just late this past week, the State Assembly said that it's going to take that up on Monday of this week. This particular bill, again, arrives after a former Covenant School student, you may remember this shooting as well, walked into that private school and opened fire, causing what? Yes, once again, a mass shooting that left 3 students and 3 school staff members dead. The case, again, gets national attention, and we know that has happened elsewhere, through not only based upon reporting, but data very generally. Since 1999, roughly 360,000 students in our nation have endured in some way school shootings in their schools. The criticism, of course, of this legislation comes fast and furious. A lot of people indicating no evidence that arming teachers will keep children safe from gun violence. At the Covenant School shooting, for example, reports showed that multiple teachers were already armed that day, and yet that was not enough to prevent those 6 children horrifically from school employees from being murdered on that day. In Tennessee, 1 in 4 deaths of children aged 17 and under were due to a firearm. That, according to statistics, offices there, the Tennessee Commission on Children and Youth. If the law becomes bill, Tennessee would join 16 other states that already enacted similar measures, again, in a way to address this issue of gun violence in our schools, but nonetheless getting a lot of criticism, a lot of pushback, both legislatively and in other ways. The bill mentions a litany of requirements for a school staff member to possess a concealed handgun on school property, such as having a handgun permit and completing a minimum of 40 hours of training specific to school policing every single year. That's drawing a lot of controversy. There seems to be another problem. The legislation lacks a storage requirement. If it's required to be put in a safe, we don't know that. A lot of things related to this legislation need to be determined, whether it's in the language of the bill itself or going forward in judicial interpretations. If indeed the state legislature passes it on Monday, goes on to the governor's desk for signature. All of that happening as America continues to wrestle with gun violence and the impact of firearms in our nation.
WAUK, Waukesha's home for Nightlight with Peach Waba.
Nightlight with Peach Waba.
I always wanted to be taller. All I wanted to do all day is play basketball. And I remember this guy from the team came in and he's having a bad day. And he looks, we're just playing a pickup game. And he goes, "Hey guys, can I get a dunk?" Somebody throws him the ball. And he runs and powers it down. And I'm like, how cool after a bad day to be able to throw a dunk down. Like, you don't get the same satisfaction with launching an angry two-handed set shot, you know.
Nightlight with Peach Waba. Weeknights 7 till 9 on your local Civic Media radio station and on the Civic Media app.
Don't you wish your life came with a warning app?
Stop. That dog does not want to be petted.
A heads up before something bad happens.
You should not send that text.
Uh-oh. Life doesn't always give you time to change the outcome, but prediabetes does. With early diagnosis and a few healthy changes, you can reverse prediabetes and prevent or delay type 2 diabetes. To learn your risk, take the 1-minute test today at doihaveprediabetes.org. Brought to you by the Ad Council and its prediabetes awareness partners.
You're listening to The Shaw, WAUK.
This is Amicus, a law review, and I'm Jim Santelle. Again, taking, as always, your questions and comments about anything that we have discussed this weekend in our broadcast. Delighted to have with us Jack from Merrimack calling in with your question or comment this morning. Jack, glad to have you with me.
Yeah, I'm not a constitutional scholar by a long shot, but from what I have read, it seems that the so-called lifetime appointments for federal judges all the way up to and including the Supreme Court is contingent, not as, and in fact is not specifically stated as lifetime appointments. It's contingent on their good behavior. And I would argue that Eileen Cannon, for sure, is at least behaving very unethically and very poorly. And my personal opinion is that she's essentially acting as a Trump defense and delay attorney. And certainly at least 4 members of the Supreme Court who decided, yeah, it would be a real good thing to decide if a president has the privileges of a king, that they decided to take that case. Again, a clear delay, an intentional delay of Trump's trials, and not to mention, of course, in Supreme Court, the obvious being on the take for hundreds of thousands or millions of dollars. Is there nothing that we can do outside of impeachment to get rid of these people?
And Jack, as always, appreciate your comment, your good question. It's all about enforcement, right? And you're absolutely right. Let's unpack a little bit of that. Let's talk about the Constitution. Indeed, it does say in Article 3 of the Constitution, which establishes the courts in our nation, that judges, including justices of the Supreme Court, stay in office during their terms of good behavior. Behavior is spelled with a U, based upon what James Madison wrote in our Constitution. Yes, you're right, Jack. That's absolutely right. It has been interpreted historically throughout our nation's history to mean lifetime tenure. It doesn't say that explicitly. That's how it's been interpreted. And so our federal judges, unlike our state judges in most places, including in the state of Wisconsin, many other cases, states where they're elected, in the federal system, the district court judges, the appellate court judges, and the Supreme Court justices, they're all nominated by the president and then confirmed by the Senate. That's the process also contemplated by the Constitution. And they remain there until one of 3 things happen. And Jack, you've identified at least a couple of those. One of them is that they remain in that office until their death. And we've seen that recently with respect to some of the Supreme Court justices. They can also retire, and we've got at least 4 former Supreme Court justices who are out there right now continuing to engage in their communities in an active way, and in many ways, big, small, and in between. And then you can also be impeached. There's only been one justice in our nation's history who has been impeached unsuccessfully removed from office. So there is some precedent out there, but again, that has not been the tradition of our nation. So the process you've got just right. And that's the process by which, again, federal judges generally are removed or otherwise move on from those positions, as Jack, you've accurately identified it. Now, the question again is enforcement. And the concern that you raised, not only about the decisions made by our Supreme Court, your concern's legitimate also about the extent to which you talked a lot about bias this weekend on our broadcast, about bias of judges and should they be recusing themselves in situations where they should not be deciding these cases. I would offer once again that one of the remedies to the kinds of things that you're identifying is a decision to recuse, whether it's Eileen Cannon, whether members of the Supreme Court, other judges and justices who may have either shown a bias in the past or have something about their own personal history, including a spouse who may be involved in issues that they're also adjudicating, other financial interests, other family interests. Recusal is the way to ensure that you've got integrity on the bench. And regrettably, that is self-policing for the most part. The Supreme Court, as you well know, Jack, has adopted, if you will, sort of a compendium of principles and of rules and so-called regulations to guide it, but it's not really the code of ethics that other judges, including district court judges and appellate court judges, should follow. And indeed, the calls like yours, Jack, for either the recusal of judges and justices in those cases that they should not be handling, or in the more extreme cases, a resignation, if in fact their behavior has gone beyond what James Madison contemplated. Those kinds of things are matters of enforcement by our nation generally. Great comment. We continue to wrestle with that, Jack, and as we go forward as a nation. And all of that, once again, raises the final comment that we're going to make today in our weekend broadcast and continue next week as well, and that is in the area of abortion. We know that the Supreme Court, in a very controversial decision in 2022, found for the first time in 49 years that a privacy right inherent in the Constitution does not, in fact, attach, and overruled Roe versus Wade in a case called Dobbs. And that, of course, has spawned a lot of legislative activity, a lot of activity in the courts of America as well. We know that just this past week, Arizona's highest court, Tuesday, upheld an 1864 law that bans nearly all abortions, and that a 4-2 decision. Physicians are now on notice, the court wrote, that all abortions, except those necessary to save a woman's life, are illegal. That in a 4-2 decision coming out of the Arizona Supreme Court, overturning a 160-year abortion ban in that state. Abortions in Wisconsin, of course, were largely halted because of an 1849 ban, but resumed in the wake of some decisions by a judge. The law did not make abortions illegal. In Michigan, for example, Governor Gretchen Whitmer signed a repeal of a 1931 ban on abortion last spring after voters there added abortion rights protections to the state constitution. Lots of things going on in that area, including this fairly controversial decision coming out of the Arizona Supreme Court. Certainly the subject of a lot of discussion in the public domain, legislative discussion as well. Again, a legislature as shown in Michigan and courts as shown here in Michigan can basically address these ancient and antiquated, if you will, abortion bans. And we'll see what happens in the state of Arizona. We know as well that the Florida Supreme Court also overturned decades of legal precedent a couple of weeks ago, also saying that the state's privacy protections do not extend to abortions, effectively allowing a Florida ban on the procedure after 6 weeks of pregnancy. We'll talk more about all of that, the rule of law inside the Constitution, privacy rights in our nation's founding document, as we continue on our weekend broadcasts. Thank you once again for joining me this weekend on Amicus, a law review, our weekend venued analysis, a review of justice law and the administration of justice in our nation. Thanks for joining me. Have a good week, everybody.
Parkway are fighting traffic on the interstates. This is The Shaw, 540 AM and 101.1 FM, WAUK.
Hey everybody, Todd Allball, Monday noon to 2. Will Matt Flynn run for Supreme Court? We'll find out. Join us on the Civic Media Radio Network.
Matt and Air on air.
So we're going to talk monarch butterflies and what we can do to help their habitat, because that's